Okay, everybody. We are at our final panel for day one, which is our plenary session on the World Conference of Indigenous Peoples from 2014 and moving forward. This panel is moderated by Elsa Stamatopoulos. She's the director of the Indigenous Peoples' Rights Program at Columbia University, where I met her, and she's my friend. Elsa joined Columbia in 2011 after 31 years of service at the United Nations. 22 of those years were dedicated to human rights, and 8 years were dedicated exclusively to Indigenous people's rights. Indigenous issues were part of Elsa's UN portfolio since 1983, and she was the first chief of the Secretariat of the United Nations Permanent Forum of Indigenous Issues. Elsa has an academic background in law, international law, criminal justice, and political science, and she's worked on international normative frameworks, institution building, the rights of Indigenous peoples, women's rights, cultural rights, development, private sector, and intergovernmental cooperation. She has authored many articles on Indigenous peoples' rights, women's rights, victim of human rights violations, cultural rights, and on the United Nations. Please welcome Elsa and our panel.
I think Carla, she's also my friend. She actually made me feel very warm when I first reached Columbia University from the UN. She showed up there in my office, and I felt in the midst of this, let us say, mainstream, a little bit impersonal university, not very friendly to things indigenous. I felt here is somebody that I can relate to in a good way. So I would like to take this moment, first of all, to congratulate the university for doing this meeting, because it would have been very unorganic and unhistorical if we had not gathered internationally to mark this very day, the actual day of the adoption of the Declaration 10 years ago. And I don't know whether it is that I am moved by being together with so many major actors in the creation of this document, or whether it's the altitude at Boulder that makes me a little dizzy today. But be that as it may, I want to say that it is impossible, having gone through so much, the movement having gone through so much, not to come up with very new and always renewed concrete steps to move forward. And in that sense, it was so inspiring to listen to all of you before, and of course to Walter Echo-Hawk's presentation earlier. So our panel is supposed to give us a sense of what the World Conference has offered us. And how is it helping us to implement the Declaration? Because the Declaration is our most comprehensive instrument. I would like to introduce our wonderful panelists. And to my left, starting from my left, Dr. Albert Barume, chairperson of the Expert Mechanism on Indigenous Peoples' Rights, and an advocate for many years. And to his left, Dr. Chandra Roy Henriksen, the chief of the Secretariat of the Permanent Forum on Indigenous Issues. And to her left, Dr. Claire Charters, associate professor at the Faculty of Law at the University of Auckland, New Zealand, Aotearoa. And to her left, Carla General, attorney with the Indian Law Resource Center. And to her left, Kim Gottschalk, attorney with the Native American Rights Fund. And each one of these colleagues and friends are amazing, and you can see their CVs in your books. 7 years after the adoption of the Declaration in 2014, the General Assembly unanimously adopted the outcome document of the World Conference on Indigenous Peoples. The outcome document was a result of a very long preparatory process Indigenous peoples themselves organized. And in 2012 and 13, they got together nationally, regionally, and internationally to prepare their own thinking and visions based actually on the declaration and thinking after the declaration on what would be the next agenda for Indigenous peoples' rights in the world. And based on that, on those consultations, they met in Alta in Norway in June 2013 and adopted the Alta document. In fact, we say sometimes that the Alta document is the one that gives Indigenous people's own vision for their own, the future post-declaration. Because of course, as is normal, the outcome document of the World Conference does not capture all the aspects of the visions of Indigenous peoples. So even if we are not very pleased with the outcome document of the World Conference, we can always look at the Alta document for that. So within the United Nations, Indigenous peoples focused in preparing for the World Conference, as much on the substance of the outcome document, but also on the process. Why was that? Because it was a crucial matter of principle to establish a process of equal participation with states, or at least some level of equality. So in June 2014, when states started to engage in the preparation of the World Conference outcome document, 2 Indigenous and 2 state advisors were appointed by the President of the General Assembly. And from June to August 2014, Indigenous and state representatives negotiated on the outcome document on an equal footing, if not formally, at least informally. And Indigenous representatives exercised quite a bit of influence on the document. And later on, however, the negotiation in September moved into a process where only state representatives were formally allowed to participate. And from then on, Indigenous peoples' representatives had to negotiate through friendly states. And all these steps of formality are very important because we are speaking here, it's the core of the expression of Indigenous people's self-determination. I think it's also worth asking at this point, what is the legal validity of the outcome document of the World Conference adopted by consensus? Is the outcome document mandatory? Is it just a General Assembly resolution, and as such, is it soft law? I am part of the school of thought that thinks that there is value and legal validity in the progressive development of international law through not only treaties, but also declarations and General Assembly resolutions. This is even more so in the case of high-level world conferences, such as the one that was held on Indigenous peoples. And based on our experience on world conferences, especially since the 1990s, I could make 7 points on what we see as characteristics of these conferences, which I think are also valid for our conference. First, world conferences unleash considerable political momentum at the international level for years to come. Second, they become an important point of reference at national and international level. Third, they give rise to new, important, and international mechanisms, and occasionally to new norms. Fourth, they may stimulate more resources to be developed to the theme of the conference. Fifth, resistance of some states to the sensitive points of the outcome document obviously manifests itself in the stages of implementation. Sixth, implementation of the outcome documents can take a long time, especially at the most contested recommendations. And seventh, the role of the advocates nationally and internationally, especially the role of civil society in using the outcome of the conference concerned and placing value on it is crucial so that the outcome can become a living document, as we say. I would like now to turn to our questions, and based on the very rich experiences that are brought by our panelists, I would like to address a little bit of specialized questions to each one of them. So we have 40 paragraphs in the outcome document, and the recommendations are directed to states and to the UN system. So I would like to turn to Albert Baruman first, chairperson of MRIP. Now, based on your experience with MRIP, what are the emerging issues and good practices that you see in the reform of the MRIP's mandate? And also, if you were to reimagine and allow yourself to dream, what would be your ideal MRIP?
Yeah, thank you. Thank you, Madam Chair. Before I try and respond to your question, let me join the other presenter to, and this is on behalf of my colleague MRIP, to thank the university, the Indian Law Resource Center, and the Permanent Forum for this very extremely important event. It's, I think it's one of the 3 or 4 that the Permanent Forum has organized. But this is a sound to be more of a substantive discussion. So my colleague, member of MRIP, who are 6, and 2 of us are here, this is a great opportunity. And the reason for that, in responding to your question, Madam Chair, is that in our view, the outcome document or the World Conference was only about implementation of the declaration. And the way we look at that in terms of what is the filigrane of the main idea of how should that landmark instrument be implemented. Our reading is, and if I have to put it in one sentence, is that the implementation of the declaration, it will be a multiple actors undertaking. And if you read the outcome document, you see interesting provision setting aside what states are expected to do, what the private sector is expected to do, what national human rights institutions are expected to do, what international financial institutions are expected to do, what the media is expected to do, and the public opinion. For us, reading the outcome document through that filigrane is critically important. And why? It is because we as MRIP, we firmly believe it is impossible to entrust the implementation of the declaration in the hand of one single actor. Because even if you read the provision of the declaration from Article 1 to Article 46, you have a clear indication that it can only be a multiple actors undertaking. And to that end, we, of course, states and indigenous people will play a leading role, an important role. My colleague will probably come to what is clearly underlined in the outcome document, most notably the national action plans that states are supposed to develop for implementing the declaration. So what, how, and why, and where does MRIP fit in all that setting? For those who are familiar with the outcome documents, they would remember that operational paragraph 28 makes specific reference to a review of MRIP mandates. That review have just been completed with two major line of intervention, if I may put it, for MRIP as entrusted with a new mandate. The first major line of intervention is it is expected from MRIP to provide a knowledge base on what the declarations and its multiple provisions actually mean or how they should be understood. For those who drafted that beautifully crafted international instrument, it is a complex instrument. It provides for rights that are framed, not new, of course, that are framed in a very particular and new way. That's, for instance, the provision on collective rights. So it is a mandate of MRIP to continuously, one, track the trends. How are those different provisions in that instrument are being implemented? What kind of interpretation are we having? Are we having restrictive interpretation? Are we having extensive interpretation? How is the judiciary taking on the different article? And from there, distill from that trends that might be positive or negative. It is also in setting that knowledge base for MRIP to continue providing analytical report of different rights with the view not only to contextualize those rights, because those rights need to be contextualized, but also to provide those multiple actors with much more clear understanding in terms of scope, in terms of weight, and in terms of right holders of those different rights enshrined into the declaration. And we look into that undertaking as a capacity building exercise. So the main major line of intervention for MRIP new mandate is capacity building through provision or providing a knowledge base by tracking practices, trends, and help to contextualize those rights. The second line of intervention in our new mandate is a new dimension to that mandate. It's for MRIP to facilitate dialogue between indigenous people and states, most notably, but also between indigenous peoples and other actors, including the private sectors. And the reason for that to be in that mandate is because it was unanimously accepted that tensions are high between indigenous peoples and states. During the negotiation process of our new mandate, many member states expressed interest in seeing those tensions somehow addressed, most notably through dialogue. That is the way we look at how the outcome document fits with MRIP new mandates. And the tool for us that we have, finishing just taking last second, is to say we are considering our reports that we produce annually as our major tool for achieving those two objectives, or those two lines of interventions. And in the one that we will be undertaking on the free, pro, and informed consent for 2018, we We will be having two major reports. The first one will be on free, prior, and informed consent, with the view to capture the trends, current global trend, the practices, and to distill knowledge out of those trends, with the view to guiding state practices, but also other multiple actor practices. The second report will be on reconciliation commissions. Again, the initial idea for that choice is to be able to capture the trends and the practices that states and other multiple actors have put in place and undertaken, with the view to diffusing tension through reconciliation commissions. What are the lessons that could be learned from those? How could those experience inspire other states where there are tensions between indigenous peoples and states, where there are tensions between indigenous people and the private sectors? Madam Chair, that's the reading we make as the expert mechanism on the right of indigenous people with regard to the outcome document as a document that frames the line for our mandate review, but also putting the last piece of the jigsaw on what we see as a mandate mostly aimed at providing knowledge, enhancing capacity, and facilitating dialogue. Thank you.
Thank you. May I now turn to Chandra Roy to ask to come to the UN system. And we know the World Conference asked for a UN system-wide plan of action, and this was adopted. What good elements or good practice elements do you see in the process of creation of this document? How do you see any positive points in its implementation? And how can we avoid bureaucratizing the outcome document and the declaration vis-à-vis the agencies? Because we saw a certain enthusiasm at the beginning after the World Conference on the part of the agencies. So how do we keep it up so it continues to be alive and inspired, if I can use this word?
Thank you very much, Elsa. And I wanted to first acknowledge Elsa herself, because as you know, Elsa was the first chief of the Secretariat of the Forum and was also there when the declaration was being adopted. So if I may ask you all for an acknowledgement of Elsa herself first. Thank you. Now, as Elsa mentions, the UN system was asked to come up with a system-wide action plan on the implementation of the declaration. First of all, we have to remember that the outcome document itself is a reaffirmation, a reiteration of the UN declaration. It was adopted by consensus, and thus, as we heard earlier today, with the reversals of positions and changes in support, it's given us an even stronger position in terms of saying that the declaration in itself has much more is of universal coverage and of universal support. Now, in the outcome document, the UN is asked, the Secretary General, in fact, is asked to come up with a system-wide action plan. Now, as you know, there are many UN agencies that operate at different levels. Some of the UN agencies have a very strong, a very big presence at the country level. For instance, I'm talking of UNDP, the UN Development Programme. There are others which operate mainly at the global level. For instance, the Convention on Biodiversity, the Secretariat, when they're there, they operate mainly on the global level, don't have such a strong country presence, which is the same for us at the UN Department of Economic and Social Affairs. Now, the reason why they wanted to have a system-wide action plan was to bring together all these different agencies that work at different levels on different areas and in different ways to see how this could better strengthen implementation of the UN Declaration. Work started on the preparation of the system-wide action plan, and I just take a moment to recognize my colleague Brody Sigurdarsson, who was the colleague from our team who worked on this day and night for nearly a year, I think. Mm-hmm. Yes. He has no more hair left, as you can see. And sorry, it's part of it, it's not all the reason. But one reason was that we had to get these 40-plus agencies, which are members of the Interagency Support Group on Indigenous Issues, which is 40-plus agencies, which are not all UN agencies, funds, and programs. For instance, we also have as member, we have the Fondo Indígena, which operates in Latin America, and which is more of an intergovernmental, has government support. So it's a different and diverse group of agencies that came together. Each one has their own mandate, each one has their operating framework and principles and guidelines. It was a challenge to get it done. And although you may think of 10 months as being a long time, it's a little bit more than having a baby. For the UN, this was like the speed of light. It was very fast. If you think of the 20 years for the declaration, the system-wide action plan was in 10 months. And one of the reasons for this was because we actually had, from the Under-Secretary General of the Economic and Social Affairs, where we are based, they said we have to get this done ASAP. So you had the system-wide action plan agreed by the agencies, adopted. It was also adopted at the highest level of the executive heads of the UN agencies, and launched by the Secretary General himself at the Permanent Forum session in April 2016. Some of the elements in the outcome document, actually, just coming back on that, because the system-wide action plan also draws on it, are areas or issues which did not feature very strongly in the declaration. For instance, the issue of data disaggregation. We all have to remember when we were working on the declaration, this was some time ago, so these are issues that were coming up. Indigenous youth. Empowerment of Indigenous women. In the outcome document, there are 6+ specific paragraphs that relate to Indigenous women. And there's also language recognizing traditional knowledge, cultural sites, private sector, just to give you some examples. Now, one of the main areas in terms of the system-wide action plan, and I come now to the question that Elsa was raising, what is the value of having the system-wide action plan? Why is it important? And why did the UN want to have a system-wide action plan developed? And the reason for that is that the UN conference, the World Conference on Indigenous Peoples, was to commit to the declaration. And that is where the UN saw there was this big implementation gap, that you had the declaration, but what was happening on the ground was not as it could be. And this is why it was the system-wide action plan was used to spur on this movement, so that there is greater engagement, greater commitment, and above all, action in terms of the work of the UN agencies in moving forward and implementing the declaration. I come back now to the question Elsa was saying, how do you avoid that the agencies will not lose interest? How will you keep the momentum now that you have the system-wide action plan? And this is where actually I would like to ask all of you for support. Because many of the discussions that we've had up to now this morning say that a lot of times in country level or in communities, there is very little knowledge of what is the UN Declaration. There's even less knowledge of what is the UN System-Wide Action Plan. There may be some knowledge of the UN, but not in terms of how it can relate to Indigenous peoples and how Indigenous peoples can move it. So I would like to appeal to all of you who are here to make sure that your colleagues, your partners, and your networks, especially at the community level, actually know about the system-wide action plan. I'll just come to some good practices that Elsa was asking us to identify. Each year, the UN Interagency Support Group has an annual meeting. And this year, for the first time, we decided to take it outside of the headquarters. Generally, it's been wherever the UN agencies have their bases. For instance, OHCHR was hosting it one year. We had it in Geneva. IFAD and FAO, which is the Food and Agriculture and International Fund for Agriculture, they hosted it in Rome. So this year we took it to Ecuador. And it's very good just to recognize that we have Diego here with us from Ecuador. And thank you very much for taking the time to be here with us. So in Ecuador, what happened was that we brought together from the different agencies, but also from different offices around the Latin American region, so they could come together and say how they are working on indigenous issues. One of the key themes, of course, because our co-chair this year is UN Women, was on indigenous women, and thank you to Lucy for placing this on the agenda of the discussion just a bit earlier. So when you have the UN country teams engaged, informed, it is very important that this is kept and the momentum is kept at the country level. We also had the Secretary General going to Peru 1 year, 2 years ago, and 2 years ago, and he himself also raised it to the UN country teams to say that this is another obligation, another responsibility you have. And this is particularly important because it is at the country level where the UN prepares what are known as national action plans, what Albert was referring to, and earlier Shankar also mentioned it. And this is where now the UN agencies are working more with greater impetus, and we are also providing support to the extent that that is possible. We will have a telecon on Monday with the UN Resident Coordinator of Ecuador to see how the UN agencies can together, in the framework of the System-Wide Action Plan, provide support to the UN country team to make sure indigenous peoples are very visible in the development assistance that they are now preparing. I'll stop here. Thank you.
Thank you very much. It just shows you how sometimes we have to become technical, but it matters because it shows how things seep in, how these documents become more real in the daily work. Thank you. I now turn to Claire Charters. Claire, we know that self-determination was not directly addressed at the outcome document of the World Conference. At the same time, there was a very novel idea in the outcome document to suggest a new system of representation of indigenous peoples at the General Assembly and at other levels in the United Nations, not as NGOs, but as indigenous peoples. And you, with Jim Anaya, were advisors to the President of the General Assembly. So what in this process, how would you characterize this process in terms of what we can draw as good examples in this process? And how do you think this can reflect at the national level, possibly in a good way? I am trying to put the positive in what we are learning through our struggles. Thank you.
Thank you very much for the invitation to be here, and thank you very much for this conference. I've really enjoyed it, and it feels wonderful to be celebrating amongst friends the 10th birthday of the adoption of the Declaration. So thanks very much, Elsa, for the question. I'm not sure that we would classify this recent experience in the General Assembly of trying to find a form of Indigenous participation at the UN as a good example, particularly. But I think there's certainly a lot to learn and a lot to think about as a result of it. Just by way of background, for those of you who might not be so aware, in Article 33 of the outcome document, it was agreed to that the General Assembly would consider ways to enable Indigenous participation as Indigenous peoples at the UN. And so that particular initiative or that particular requirement for the General Assembly to look at this had a pedigree in the expert mechanism and its work with respect to participation in decision making. And the Human Rights Council through the authorised Secretary General reports on this, and especially in the ALTA document. And I just want to recite the ALTA document with respect to this because it goes and highlights the self-determination, sovereignty, I guess, elements behind this particular movement to enhance Indigenous participation. So it says, pursuant to the universal application of the right of self-determination for all peoples, recommends that the UN recognise Indigenous peoples and nations based on our original free existence, inherent sovereignty, and the right of self-determination in international law. We call for, at a minimum, permanent observer status within the UN, enabling our direct participation through our own governments and parliaments. Our own governments include, inter alia, our traditional councils and authorities. So you can see there that the idea coming from ALTA particularly was around self-determination, also ideas of sovereignty that was coming through, this idea that Indigenous peoples need to participate in the UN as Indigenous peoples as a reflection of this, of the right to self-determination and inherent sovereignty. So, as mentioned as part of this process, the President of the General Assembly appointed 4 advisors to assist him, and it was certainly a privilege to be appointed alongside Jim as one of the Indigenous advisors, alongside our 2 colleagues, permanent representative of Finland and permanent representative of Ghana. And thank you very much, I should add, in this context, for the confidence that was instilled in us and shown towards us for this appointment. It was certainly an honour, and I very much appreciate the privilege of being in this role. Now, the process started, I think, with a good deal of optimism, especially during the time that Indigenous peoples were included in the consultations. And certainly my perception up until, I think, late May this year, or maybe even up until early June, was that Indigenous institutions would certainly have a unique status recognised, that there would be some form of participation in the General Assembly, that Indigenous would be involved in the process to select Indigenous institutions for status, which is really looking at Indigenous governments and other forms of representative structures, and that there would not be a need for a strict definition of Indigenous peoples, and there would not be a need for state recognition as a mandatory criteria. That was certainly, I think, Jim would share that view. I wouldn't speak for him, obviously, but that there was certainly that confidence that something along those lines was likely. But I think in the very last negotiations that were intergovernmental only, so it didn't include Indigenous peoples in the room, certainly this process was stalled, and it was always clear to us that there were some states who were very resistant to some of these ideas. For example, participation in the General Assembly. They wanted that under the General Assembly, certainly not in the General Assembly. Wanted state recognition as a mandatory criteria, and wanted a veto right effectively to determine who was Indigenous and who was not Indigenous. And I guess we had been optimistic in the sense that that didn't seem to reflect the preponderance of views amongst states, and also we expected to see some shifting in positions as we had in the declaration negotiations, right, that certain states were holding out, but at the very end they shifted towards some form of support. So we were expecting that to happen. But it turns out that the so-called, they called themselves the like-minded states, were really not prepared to move on those issues, which meant that, in effect, they were trying to relitigate, I think, issues that had been avoided in the declaration. And I was saying last night that in some ways I think the declaration in this process has been the victim of its own success. States fear, I guess, some states fear recognising Indigenous peoples because of the rights that might entail, and in this case could include then participation at the General Assembly. So really those like-minded states didn't move, and that meant that we could not reach a consensus between those states and those states that were more supportive. So the politics behind this was obviously interesting. Certainly the process was very tense and frustrating. There are a lot of loud voices like there were during the declaration negotiations. And all the positions and steps taken throughout the process were highly nuanced. But I just wanted to capture a few things about the politics, I guess. And there were a number of very supportive states who were very proactive and very supportive, But interestingly, even the most supportive states' views did not align perfectly with Indigenous people's views. So, for example, participation in the GA and the General Assembly was made clear to us was one of the most important things for Indigenous peoples. But that then also became the first trade-off. So it was the first thing to go, was this participation in the General Assembly level. And that's, the supportive states, I guess, gave that up first, which I think was contrary to really the fundamental view of Indigenous. And other states could not accept a veto, but were more open-minded with respect to the requirement of state recognition, I think. And of course, this requirement of state recognition had been resisted by Indigenous peoples strenuously. And for Indigenous, as Jim said at the time, this is really where the sort of rubber hit the road with respect to state recognition of Indigenous peoples. And there was, I think, tension within the Indigenous caucus, Indigenous movement. Was it better to have some Indigenous side inside the system who had state recognition to set a precedent so that the UN could be opened up to all at a later point? Or would that be discriminatory, and would that set in stone exclusionary rules, meaning that there would essentially be a hierarchy of Indigenous peoples' organisations with respect to participation at the UN, with potentially wider consequences? But in the end, I think, and this was heartening, and this is a good message to take, there was considerable Indigenous solidarity that a resolution excluding some Indigenous peoples in effect could not be adopted, and I think that was important. And I think our greatest concern as advisors was that the outcome, not in the finish, it didn't start out this way, but in the finish was that the outcome not undermine the Declaration on the Rights of Indigenous Peoples. And we saw this potentially under threat with states wanting to control and to determine who was Indigenous. So the alternative, and what was adopted then on Friday last week, was what we called the so-called nuclear option. And this was a resolution that had a general statement of encouragement to the UN to enhance participation, and then with a process set in stone to revisit this issue in the future. And perhaps somewhat naively, we thought that this would be relatively straightforward once we realised we couldn't get substantive consensus that this would be straightforward. But it turned out that this was not easy either, and this was highly contested to have, the second option, the alternative option, which was meant to be meant to be relatively easy. One of the things that happened in the corridors when Jim and I were not there was that states came to an agreement that really set out simply just a process to revisit this issue in the future and to exclude the general encouragement to enhance Indigenous peoples. And it was only because of, I think, last-minute intervention by Indigenous that we secured this general call for enhancement of Indigenous people's participation at the UN. And I really would hope that this might provide the authority or the impetus for distinct parts of the UN to make provision for participation of Indigenous as Indigenous peoples, such as maybe the Human Rights Council. I think there needs to be a lot of thought about how to move this process, but that is certainly an option on the table. I also hope that we as Indigenous can plan well for the next round of this issue, the next push on this issue. And it would be really important we have a solid and very important to have a multi-regional strategy that involves Indigenous peoples from all regions to shift thinking, especially those of the like-minded. Because it's important to note that the views of the like-minded states have been the same since the start of declaration negotiations. These are the same views since the 80s that have really come to the fore in this particular process. But I do want to sort of leave on a positive note, and I did pick up this morning that Ambassador Chavez said at the beginning with respect to the declaration that in the end justice will prevail over states' fears. And I certainly hope that is the case with respect to this issue. And I hope that we can gather around to support this particular kaupapa, as we would say at home, in the future for the progressive development. So thank you.
We now turn to the national level. We have two attorneys of extraordinary organizations in this country. To Carla General, I would like to ask, in the work of your organization at policy level, advocacy, as well as legal work before the courts, how does the declaration and the World Conference document help you, if at all? And would you imagine in a federal state like this country is, what potential could we see in terms of adopting at state level some plans of action, or even at city level or county level? In other words, how can we see things becoming more concrete and using these documents in our work?
Thank you. Thank you, Elsa, for the introduction, and for my fellow panelists for all of your insights and experience and expertise on all of these really complex issues when you get into dealing with the United Nations and trying to implement what has become a complex document, but what I think at the heart of all Indigenous peoples, we know what we want, we know what the end goal is. I just want to say thank you to everybody. I'm from the Mohawk Nation of Akwesasne, and I bring greetings on behalf of our Executive Director, Tim Coulter, who is grateful for this opportunity to have the Indian Law Resource Center represented here on this panel. I want to recognize the work of everyone in this room who contributed to the development of the UN Declaration and the implementation of our rights before the Declaration and also after the Declaration, as well as my great-grandfather, who was Chief Daskahe, Levi General of the Cayuga Nation, who went to the League of Nations in 1923. So I'm very grateful for all of that work and all of the sacrifices that were made on our behalf to continue this work and continue fighting for our basic human rights and our right to exist. From our point of view, to answer your question, the World Conference was a key or a critical opportunity to do two things. The first was to raise awareness of the Declaration. As many have pointed out, not many governments know about the Declaration, even though they've consented to it. And also to operationalize or put into action the rights of Indigenous peoples. So together, beginning in 2012, with over 150 tribal nations and organizations, the Indian Law Resource Center with our partners and colleagues prepared and developed some early proposals for those concrete changes that the UN could take that would be most responsive to promoting Indigenous peoples' rights and to respond to violations of these rights. And though it is far too soon, I think, to assess the direct impacts of the World Conference on national laws and policies, I think that for the most part, two of the procedural or long-term proposals that are reflected in OP 28 and OP 33 concerning the strengthening of the MRIP and the enhancement or attempted enhancement at the participation of Indigenous peoples' governments at the United Nations are key items on the table that will lead to long-term improvements for Indigenous peoples' rights. Another substantive area that we focused on in preparing for the conference was to get UN attention to the issue of violence against Indigenous women. You may already be aware of the alarming statistics in the United States. And today, in 2017, more than 4 in 5 American Indian and Alaska Native women have experienced some form of violence. And more than 1 in 2 have experienced sexual violence, mostly at the hands of non-Native or non-Indian offenders. And so OP 17, 18, and 19 dedicate some attention to this very real issue that a lot of our communities are dealing with. And they also invited the Human Rights Council and the Commission on the Status of Women to consider the issue. So I think a successful outcome there was increased attention overall in the UN, where 10 years ago they weren't ready to hear about this issue or they didn't want to talk about it. And now it's throughout the UN, and nobody denies that this is a major human rights crisis. And I also think it opened new advocacy spaces for us regarding the Violence Against Women Act and domestic legislation, the Tribal Law and Order Act in the United States. And it helped to generate increased attention among Indigenous advocates and leaders in the international work, though it is, again, difficult to say that this has led to substantial change domestically. The outcome document of the World Conference as a consensus document is important because, as Chandra points out, it recommits all member states. It reminds them of their human rights obligations. So thereby it's a bit repetitive of the declaration. So it reaffirms rights to culture, language, and health, rights of Indigenous women and children to live free of violence and discrimination, and provides access to sacred sites and repatriation of human remains and objects. It's also significant because it resulted in several new commitments by member states to establish permanent mechanisms at the national and international level with the intended effect of further operationalizing the declaration. At the national level, for instance, paragraph 8 of the outcome document commits member states to develop and implement with Indigenous peoples representative institutions, national action plans, strategies, or other measures to achieve the ends of the declaration. And though Article 42 of the declaration already calls for states to promote full application of the declaration, it's always good to remind them of their commitments, because few have actually taken any concrete steps to do any of this. The outcome document thereby attempts to fill this gap by creating a framework for implementation at the country level, which would be these so-called national action plans. I think such plans can be good practice as a collaborative activity that countries and Indigenous peoples can take to build trust, mutual understanding, and respect when putting their rights into action. A plan can serve to raise awareness of the declaration among government officials, corporations, and the private sector, civil society, and the general public, and it can generate responsive actions to strengthen legal and political protections for Indigenous peoples' rights and to prevent human rights violations. It could result in stronger legal frameworks grounded in international human rights norms, more effective incorporation of human rights standards in domestic law, and more effective rule of law. But a plan is not absolutely necessary to operationalize the declaration. I think tribal leaders, their attorneys and advocates and academics can all implement the declaration right now without a plan, though a plan is desirable. It has been 10 years without a plan, and I think tribal leaders and attorneys have taken good steps forward to operationalize the declaration. As a few examples of what can be done in the United States, for instance, tribal leaders can call on the administration to issue an executive order requesting all federal departments and agencies to conduct a review of their programs, regulations, and policies to determine whether they are in compliance with the declaration, and if not, how they can be brought into compliance. They can also call for a review of existing legislation that can be reformed. Like law reform is a major platform that Walter Acquahawk discussed earlier to meet the minimum standards of the declaration. Attorneys can cite the declaration in federal briefs, in arguments and cases, and maybe we'll get over the hurdle of being called crazy, and the further that we can institutionalize and incorporate the declaration into our work, like other Indigenous peoples have successfully done in other countries, to argue for more favorable interpretations of federal statutes, treaties, and regulations. Tribal leaders can adopt a resolution endorsing the declaration and calling on the national and state governments to respect those rights that are set out in the instrument. Following adoption, they can send a letter to the administration and Congress announcing endorsement and pointing out the importance of certain rights, requesting government officials to read the declaration and to give appropriate attention to the rights that it proclaims. Tribal leaders can call for the administration to circulate, distribute, and educate its officials, as well as the general public, about the declaration. And they can also designate and send representatives to participate in meetings and activities at the United Nations, especially the future meetings. As Dr. Charters mentioned, there's a multi-year calendar of consultations and interactive hearings that have been laid out in the recently adopted resolution over the next 4 years in New York, and regional consultations around the world will also happen. And so the tribal leaders can designate and send representatives, because there really is no substitute, as others have emphasized earlier today, for having Indigenous leaders meeting face-to-face with member states to try to work through any disagreements on key issues and to advocate for UN policies and procedures that can permanently benefit Indigenous peoples. I think such intense meetings were had before the World Conference outcome document, and it would be really beneficial to continue advocating in person for other changes. So back to the question about national action plans. In spite of the call of the World Conference for states to develop these plans, policies, or strategies, the United States has yet to take any steps toward meeting this commitment. While the US has adopted similar national action plans on women, peace, and security, and also to promote responsible business conduct by US enterprises operating abroad, they refuse to support a recent plan of action to implement the new American Declaration on the Rights of Indigenous Peoples, which was adopted by the Organization of American States General Assembly in June. And I have a few copies here of the declaration that was adopted last year. The plan of action was adopted this year, just a few months ago, and the US cited its persistent objector status to the American Declaration as a reason for not joining. with consensus on that plan of action. So that regional plan of action, I encourage everyone to review. It's incredibly important for the future of Indigenous rights in the Americas, and it could be a good practice in the future. It's a 4-year plan of action that outlines steps to attempt to create an implementing body in the Americas through the Organization of American States, as well as dedicate an annual meeting with tribal leaders and Indigenous leaders to discuss implementation of the American Declaration. Other countries like Ecuador are also in the process of developing national action plans. Also in 2017, in its report to the Human Rights Council, the MRIP calls on states to meet their commitment to adopt national action plans, which is a really welcome recommendation. I think the new MRIP mandate presents a promising way forward. The mandate provides authority for MRIP to provide states and Indigenous peoples with technical advice regarding the development of domestic legislation and policies relating to the rights of Indigenous peoples. This is a key new tool that cannot be overlooked. We have heard from some in the UN that the new authority of MRIP is restricted to facilitating dialogue and providing technical assistance from afar. This cannot be so, and Indigenous peoples must boldly question these self-imposed limitations. The new mandate is the product of many consultations and advice provided by Indigenous peoples and member states with the common understanding that the new MRIP is intended to be an independent, credible expert body responsible for monitoring states' compliance with the declaration. Beyond offering technical advice, the MRIP can also seek information from Indigenous peoples on the ground. It can conduct country visits. It can prepare expert reports to provide the UN the facts needed to respond seriously and effectively to the most horrific violations of our Indigenous rights, including the killings of land rights defenders, the issue of violence against Indigenous women, the land grabs, the issue of climate change, several issues that they can provide expert facts to the UN to make informed decisions. In 2016 alone, 281 human rights defenders were murdered in 25 countries, more than double the number who died in 2014, and half of them were working to defend land, Indigenous, and environmental rights. So Indigenous leaders, lawyers, and advocates must all be aware of new protections in international law for Indigenous peoples and the new authority of the MRIP mandate, and should look to it and other international tools for making their legal and policy arguments and working toward securing justice, protection, and rights, respect for Indigenous rights, and an end to human rights violations of Indigenous peoples. So to summarize, and to go back to your question about the opportunities for local governments or counties or states to develop their own action plans, I think that's a good recommendation and a very welcome one, that it would provide a sense of collaboration and mutual respect building among local governments with Indigenous peoples. And that's similar in the case of, I think they call them human rights cities, which have also adopted resolutions. I think there's about a dozen or so cities in the United States that have adopted resolutions declaring their support to not only the Universal Declaration on Human Rights, but other human rights treaties that the U.S. has not ratified.
Okay. Thank you very much, Carla. There is such richness on this panel. Kim Gottschalk, you have worked tirelessly for so long on defending land rights, representation issues. You direct the legal affairs of your organization, in particular, including litigation. So what opportunities do you see emerging issues do you see after the adoption of the declaration and after the World Conference?
Okay, well, first of all, I want to give thanks for being invited to be on this panel and to acknowledge the First Peoples of this land. And I want to make clear that I don't unilaterally direct the litigation. I'm on the Litigation Management Committee at the Native American Rights Fund. I'm part of a team, and it's a team effort. But I'm painfully aware that I'm going to touch a little bit on what Bunky was talking about, and that I can't possibly match his eloquence. So I apologize at the beginning. But I'd like to just point out a few things where the disparity between national law and the Declaration is so great that it has to be taken into account. And Article 7 of the World Conference outcome document recognizes the need to raise awareness of the judiciary. In fact, commits the states to raise that awareness. And it's easy to forget that Indian law, as Felix Cohen pointed out, is first and foremost rooted in international law and is best still viewed as part of international law. But in the United States, that has been lost sight of. We go from the Kagama case, where the Commerce Clause was construed very narrowly and not viewed as a source of power to enact the Major Crimes Act, to Cotton Petroleum, where the sole purpose virtually of the Indian Commerce Clause is to grant Congress plenary power over Indian affairs. And so while international standards have evolved and improved, the US standards haven't, because they've been cut off from those roots. So I think we have an opportunity, and really what we need to do, and what I think about in litigation at the Native American Rights Fund, is how can we tie the development of Indian law back to its Indian law roots and convince courts we're not doing something totally new and drastic. We're actually going back to what was originally the source. And I have to acknowledge at the beginning that international law, the connection to international law previously was not always felicitous. There's a case called Roper versus Simmons, where the United States Supreme Court struck down the death penalty for people who committed crimes prior to 18 years of age. And the court cited the Convention on the Rights of the Child. Well, the United States is not a party to the Convention on the Rights of the Child, but the court said that there was a necessity of referring to the evolving standards of decency that mark the progress of a maturing society. And I suppose you could look at that as a statement of recognition of human rights. And so that even though the United States maintains that the Declaration is not legally binding, that does not mean that it should not be honored and respected. So I just want to pick out just a handful of areas. One is, of course, the heart of the Declaration is self-determination. And I think back to law school, and I have this vague recollection of a term called legally operative fact. Whether you take the Declaration as binding or not, it seems to me it's a legally operative fact. And let me explain what I mean by putting it in context. The Yakama Nation brought a lawsuit alleging that Public Law 280 infringed on its right of self-government. Now, in the United States, there's an equal protection clause which says you have the right to be treated, similar people should be treated similarly. If classifications are made that are suspect, like race, they're subject to strict scrutiny, which means they can only be done for the most compelling reasons, and then in the narrowest way possible can you address the problem. That also is true of fundamental rights. And the Yakama Nation said, this act infringes on our right of self-government. And the Supreme Court said that the argument that diminishing the sovereignty of an Indian tribe by diminishing their government was a fundamental right was an untenable argument, as astounding as that sounds. Now you have the Declaration where 150 nations of the world say, Indigenous peoples have the right of self-determination. We acknowledge that and recognize that. I hope somewhere, maybe at NARF, maybe somebody out there who comes up with a similar case in the future where you want to argue that something infringes on tribal self-government and is subject to strict scrutiny, that's an argument that can be made to use the Declaration. Another one is Article 2, which says Indigenous peoples are free and equal to all other peoples. In the case of United States versus Lara, in which the court addressed the question of whether the Congress could correct a decision of the Supreme Court in Duro versus Reyna, which said there was not criminal jurisdiction by one tribe over members of another tribe. In dictum, they said, Congress can even terminate the existence of individual tribes. That is just an astounding statement to appear in a case. I guess it sounds like genocide to me, and certainly violates the notion that indigenous peoples are free and equal to all other peoples. And then, of course, and this is all addressed to some of Walter's point about addressing the dark side. And of course, the big issue is plenary power, which basically is the basis of this idea that they could terminate the existence of tribes, but they can do anything else they want, according to the Supreme Court. And I would compare and contrast that to paragraph 2 of Article 46 of the Declaration. In the exercise of the rights enunciated in the present Declaration, human rights and fundamental freedoms of all shall be respected. The exercise of the rights set forth in this declaration shall be subject only to such limitations as are determined by law and in accordance with international human rights obligations. Any such limitations shall be non-discriminatory and strictly necessary solely for the purpose of securing due recognition and respect for the rights and freedoms of others and for meeting the just and most compelling requirements of a democratic society. That's a far cry from the idea that Congress can do anything it wants to restrict the rights of indigenous peoples. So I'm not naive enough to think we're going to easily overturn that, but as a very modest proposal, what I've taken upon myself is I don't use plenary power in a brief. And there's a temptation sometimes to do that. For example, in the Lara case, did Congress have authority to change the Supreme Court decision that said that one tribe doesn't have criminal jurisdiction over members of another tribe? The brief had all kinds of references to plenary power because the tendency was to say that doctrine is used against us all the time, so when we can use it in our favor, we want to do it. I think that's a mistake. I think we're aiding and abetting the process. So it's a small thing to do to eliminate that from the briefs. In fact, what Congress was doing in the Lara case was fixing common law, which is what they do all the time. There's absolutely no need to refer to plenary power. But I will note that I saw somewhere recently that the Goldberg Institute, in challenging ICWA, is saying that Congress does not have plenary power over Indian affairs. So there's a very interesting case where someone is arguing that they would need plenary power to do it. I still hope that whoever addresses this doesn't run to embrace the concept of plenary power. There are at least, if they do need to mention it, there are at least two aspects to it. One is the power is broad enough so that it can deal with these issues, and the other one that is more insidious is that the power is deep enough that Congress can do anything it wants. If there is an absolute need to mention plenary power, it should be clarified which of those two is being appealed to. Those are just a few of the ideas that one idiosyncratic lawyer has about how to maybe make entree here. I would like to mention one thing, though, that on the international level, paragraph 36 of the outcome document says that indigenous traditional knowledge must be taken into account in climate change action at the local, national, and international level. And Article 31 of the UN Declaration says that indigenous peoples have the right to maintain and control their traditional knowledge. So now we have an article saying, and you got to take it into account. And then we go one step further a year later to the Paris Agreement, where in the preamble, for the first time ever in an environmental document, there's a legally binding reference to the rights of indigenous peoples. And in Article 7, subparagraph 5, an acknowledgement of the importance of traditional knowledge. And in paragraph 135 of the decision, the establishment of a traditional knowledge platform. And I just got back from Ottawa, where I was there with Daley, and we're talking about how is this platform going to work to bring traditional knowledge to bear to increase the leverage of Indigenous peoples as subjects in the international process, which then raises the other problem of the dangers of using traditional knowledge, and we're also involved in that aspect of it in WIPO, and how do you protect traditional knowledge. But I just wanted to bring that example up because it's so current and so timely, but maybe I've said enough.
Thank you so much. Each one of these topics that our panelists broached could become a separate panel, and I don't know if we have permission for 2 questions from the audience before we break. Yes, Diego, and then...
Bueno, haré el uso de la palabra en español ya que tenemos esta oportunidad. Muchas gracias, Elsa. Mi intervención no es una pregunta, más bien un comentario. En primer lugar, que me congratulo por la iniciativa de la universidad, así como con la Secretaría del Foro Permanente de organizar esta reunión. Yo creo que este tipo de eventos, y más aún cuando marcan fechas o conmemoran una fecha importante como la del día de hoy, son fundamentales para seguir aprendiendo y socializando los avances que se han alcanzado en lo relativo a los derechos de los pueblos indígenas en el ámbito internacional. El documento final de la Conferencia Mundial ciertamente es uno de esos logros y creo que los avances que se han realizado y demuestra que es uno de los avances que podemos tener o que hemos tenido en esta década de la Declaración de Pueblos Indígenas. Y quiero resaltar justamente que hoy tenemos interpretación, porque me parece que tanto para la realización de los compromisos que se reflejan en el documento de la Conferencia Mundial sobre Pueblos Indígenas, así como para que se cumplan los derechos contemplados en la Declaración sobre los Derechos de los Pueblos Indígenas, es primordial considerar lo relativo a los idiomas. Y de esta manera contar con mayor participación de pueblos indígenas de América Latina y de otras partes del mundo que no somos fluidos en el inglés. Y con ello yo quiero retomar un poco lo que había expresado Tarsila en la mañana, ¿no? Que hay desafíos, hay cuestiones con problemáticas que se han manejado para alcanzar para que se adopte, por ejemplo, la Declaración de Pueblos Indígenas, el proceso de negociación en el que estuvieron inmersos o se contó con participación de indígenas de varias regiones del mundo en el documento final de pueblos indígenas, por ejemplo. Pero yo creo que para indígenas precisamente que venimos de otras regiones que no somos fluidos en el inglés, agudizan más los desafíos. Entonces, superar esas barreras es fundamental para los futuros avances que vienen, porque me parece que deberíamos poder buscar la manera de facilitar ello, de facilitar que tengamos un aporte mayor de otras regiones también. Y ahí, como decía, posiblemente promover más programas de capacitación en idiomas y temas sustantivos sobre pueblos indígenas para quienes no hablamos fluidamente el inglés. Y por otro lado, que en eventos, en reuniones, que se considere la interpretación o traducción, ¿no? En los documentos, incluso cuando se tratan de temas relativos a nosotros o que nos afectan. Y ello, pues, yo creo que va a enriquecer aún más los futuros avances, porque creo que esa voz que viene también desde las otras regiones puede mejorar justamente todo lo que se ha realizado, lo que se ha venido realizando en estos años y los desafíos que nos quedan por delante. Yes. Ese es mi comentario.
Yes.
Gracias.
Thank you. For the friends that didn't have their earphones on and maybe they didn't understand what the question that was put forward as a challenge is the language obstacle and the gap between indigenous peoples, when indigenous peoples from Spanish-speaking areas come, and not just Spanish-speaking, but from other areas, that this is a challenge we have to overcome in international debates. There was another question over there.
Good afternoon. My question is, over the past 10 years, which member state has honored the aspirations of the UN Declaration on the Rights of Indigenous Peoples the best?
Okay. So would any of our panelists like to address this fundamental and symbolic question, I would say, very important question? I think that your silence, right?
The most recent.
Would you like to say something, Claire?
Well, only because I felt all these eyes turn to me, so I guess I can give it a go. On the first question with respect to language, this was obviously an issue in these most recent negotiations, I guess, and consultations around Indigenous participation at the UN. And it was very Anglo-centric, I think, in part because that's where the vast majority of Indigenous peoples who were pushing this agenda were coming from English-speaking countries, frankly, as you know, as very well from your perspective as well. And I agree with you, basically, that I think that it's really important that all regions are represented, and that is made possible, sorry, have I got a microphone? That is made possible through translation. But I mean, in saying that, there's the added complication, of course, that they're not Indigenous languages. It's going from one colonising language to another colonising language. You know, I think of my own kids who are learning to speak Te Reo Māori in a bilingual school, and that they'll never be able to, I don't think, go and speak Te Reo in the UN. So it's a complicated thing, and it does reflect a power structure. And so the best that can be done, I guess, is to provide translation. That's really important. I have no answer for that one. For the second question on which country do I think has done the best, I don't think there is an answer, even if I had the best understanding of all regions in the world. I think Vicky or Jim might be able to make a better attempt at answering that question, because I think in their roles as special rapporteur they see firsthand different situations more closely. I mean, I would hazard to sort of say that there are some countries that have taken some big steps, I guess. And I think of Bolivia with respect to the declaration, for example. I think of some references, the fact that New Zealand Supreme Court is citing the declaration and its jurisprudence. You know, that's not to say any is better, but there are sort of, going to the implementation panel, there are steps where some states, Canada's recent statement at least, whether it's going to be followed up in practice is in question, but statement at least that it's going to now comply with the declaration and is looking to change the laws consistent with the declaration. I mean, I think there are some good trends in terms of states being recognising and bringing into law and policy, I guess, the declaration, but comparisons are very difficult, I think, because context is so different. But it's a good question in a way, because it's, yeah.
Albert would like to say something.
I think it's really an extremely difficult question. It's a legitimate question, but it's an extremely difficult one. The Emory Plus report to the Council, which we'll be submitting next week, gives an overview of how far states have gone in implementing the declaration, to a certain extent. I'm not going to, the report doesn't actually give a clear answer to your question. But what the report does capture is that most of the effort made during the last years has mostly been standard setting and institution setting. Countries that have either tried to modify laws or adopt new laws, set institution, National Reconciliation Commission, Special Ministry for Indigenous People, Special Commission for Indigenous People. We did somehow for really trying to capture those practices. And our conclusion in that report is yes is one thing, setting the standard or establishing institutions. But it's halfway down to changing the living condition of indigenous communities where it matters. So the conclusion of that report is saying, yes, the trend is there, but we are not there yet in terms of transforming the living condition of indigenous people. Thank you, Madam Chair.
Maybe I can just add, because we had a report that we prepared for the Permanent Forum earlier this year, and we looked through some of the examples that had. It's not a black and white answer that, yes, this country is doing fantastic. Some countries are doing very well, and some countries are actually doing quite well in some instances. For instance, we looked through in terms of language, indigenous languages, and found that in some of the countries in Africa, where there is a whole different concept of conceptualization of indigenous peoples who are indigenous peoples, yet in some countries in Africa, I'm trying to remember, I think it was Morocco and Algeria, they actually recognize the Amazigh language as an official language. So, and this has come about quite recently. Yet in others, there are also steps being taken in some countries in Asia, for example, where they are bringing in, and this responds to the question raised by our colleague from Ecuador that about indigenous languages. In some countries, for instance, even in Bangladesh, my country, where there's a whole issue around political implications of the term indigenous peoples, yet there are steps being taken through some of the UN agencies to provide instruction in mother tongue to some of indigenous communities, to the children. So, it's a bit varied that in languages you have some of these issues coming up, but yet you look in terms of some of the resources that are being provided, there've been steps back in terms of that. But in others, there are also steps being taken. I'm just looking, for instance, if you'll excuse me, Shankar, our colleague from Nepal, pointed out, Nepal is a very good example where you have some steps forward, then there's a change of government, and then the status quo is changed, and it's almost as if it is a little bit not so progressive as it could have been or it was earlier. So it's very, very nuanced, and at the moment we're sort of looking into it. We are just take this moment to also say that we are going to be preparing a commemorative edition of the UN Declaration 10 years after. In fact, we've asked Max Oft to help us with that. And this is one of the issues we want to look at. But one major challenge there also is that statistics are very difficult to find. And where they are disaggregated, even in terms of gender, it's very little that they point specifically to indigenous peoples. Australia, in fact, is one of the countries where we have had some statistics in terms of standard of life.
Thank you very much. And before I thank you, I want to say that the density of this panel is simply, which oversteps the temporal limits of the organizers, is just a testimony to actually the richness, the density of the indigenous peoples movement. Because all this that is being described, all this work, all this dense work, would not have happened without the sustained indigenous peoples movement over the years, the decades. And I feel that what we have all noticed in this movement as well is that the movement always aimed at winning hearts and minds and at keeping the high moral ground, the moral high ground. Yes. And so with these words, I think we are leading, our panel looking forward to the future is leading us to tomorrow's working groups. And I want to thank you very warmly for these rich presentations. Thank you so much.
Thank you, Elsa, and members of the panel. Each of these panels could probably be a conference in and of itself. I agree that our discussions have been really rich, really illuminating, very inspiring. So thank you all for your time and attention today, and to our panelists and moderators. It's time to celebrate. This is a birthday party after all, as Claire said. We have a traditional cultural celebration that will be taking place in the courtyard just as soon as everyone gets out there, with food, music, dancing, singing. I've been told the clouds just parted and the rain just stopped, so we can make our way out there. A couple of administrative items before you all go. If you wouldn't mind grabbing your headset and putting it in the basket at the welcome table on your way out, as well as removing your name tag and putting that in the basket on the way out so you can have it for tomorrow. You may have noticed that there's a piece of paper inside your name tag that's yellow. That's your group number for tomorrow. And when you show up tomorrow, there will be signs that will direct you to the rooms for the working groups. Thank you all very much.